Mueller Report, Volume 2, Track 5, Section 2.1, Background Legal and Evidentiary Principles. A. Legal Framework of Obstruction of Justice. The May 17, 2017 Appointment Order and the Special Counsel Regulations provide this office with jurisdiction to investigate federal crimes committed in the course of, and with intent to interfere with, the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. 28 CFR. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. See Justice Manual Section 927. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report addressing constitutional defenses that the President's counsel have raised. See Volume 2, Section 3B. Infra. 3 basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding. And 3. A corrupt intent. See, for example, 18 U.S.C. citations. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering, see 18 U.S.C., and describe the requirements for attempted offenses and endeavors to obstruct justice. See 18 U.S.C. citations. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered, regardless of the means employed. U.S. v. Silverman. Interpreting 18 U.S.C. An effort to influence a proceeding can qualify as an endeavor to obstruct justice even if the effort was subtle or circuitous and however cleverly or with whatever cloaking of purpose it was made. U.S. v. Roe, 1975, see also U.S. v. Quattrone, 2006. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. Marinello v. U.S. 2018, internal brackets and quotation marks omitted. An improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful and within the actor's authority. See U.S. v. Quito, 151 F.3d 620, 631, 7th Sir. 1998, affirming obstruction conviction of a criminal defense attorney for litigation-related conduct. U.S. v. Simplo, 818 F.2d 980, 992, 1st Sir. 1987, any act by any party, whether lawful or unlawful on its face, may abridge Section 1503 if performed with a corrupt motive. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus, or connection, to an official proceeding. In Section 1503, the nexus must be to pending judicial or grand jury proceedings. U.S. v. Aguilar, 515 U.S. 593, 599, 1995. In Section 1505, the nexus can include a connection to a pending federal agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. Id. At 599, see also Arthur Anderson LLP v. U.S., 2005. Section 1512 prohibits obstructive efforts aimed at official proceedings including judicial or grand jury proceedings. 18 U.S.C. Section 1515. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense, although a proceeding need not already be in progress to trigger liability under Section 1512c. A nexus to a contemplated proceeding still must be shown. U.S. v. Young, 2019. U.S. v. Petruk, 2015, U.S. v. Phillips, 2009, U.S. v. Reich, 2007. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. Aguilar, 515 U.S. internal quotation marks submitted. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful. Aguilar, 515 U.S. emphasis added, internal quotation marks submitted. The endeavor must have the natural and probable effect of interfering with the due administration of justice. Id. At 599, citation and internal quotation marks submitted. As a subjective matter, the actor must have contemplated a particular, foreseeable proceeding. Petruk, 781. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. U.S. v. Martinez, 2017, brackets, ellipses, and internal quotation marks submitted. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly or with an improper motive. U.S. v. Richardson, 676 F.3 D 491, 508, 5th Sir. 2012, U.S. v. Gordon, 2013. To act corruptly means to act with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede or obstruct the relevant proceeding. Some quotation marks submitted. See 18 U.S.C. Section 1515b. As used in Section 1505, the term corruptly means acting with an improper purpose, personally or by influencing another. See also Arthur Anderson, 544 U.S. interpreting corruptly to mean wrongful, immoral, depraved, or evil and holding that acting knowingly. Corruptly in 18 U.S.C. requires consciousness of wrongdoing. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. Ballantyne's Law Dictionary, see U.S. v. Pasha, 2015. Aguilar, Scalia, J., concurring in part and dissenting in part, characterizing this definition as the long-standing and well-accepted meaning of corruptly. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. See 18 U.S.C. making it a crime to knowingly use intimidation, or corruptly persuade another person, or engage in misleading conduct towards another person, with the intent to influence, delay, or prevent the testimony of any person in an official proceeding or to hinder, delay, or prevent the communication to a law enforcement officer. Of information relating to the commission or possible commission of a federal offense. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. U.S. v. Edlund, and other citations. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, sparks, 791, or coach or remind witnesses by planting misleading facts. Edlund, 887. Corrupt persuasion is shown where a defendant tells a potential witness a false story as if the story were true, intending that the witness believe the story and testify to it. U.S. v. Rodelitz, 1986, see U.S. v. Gabriel, 1997. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. C/A, 417. Corrupt persuasion also can be shown in certain circumstances when a person, with an improper motive, urges a witness not to cooperate with law enforcement. See U.S. v. Schatz, 1998, telling secretary not to say anything to the FBI and she would not be bothered. When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512, annexes to a preceding inquiry articulated in either that an individual have knowledge that his actions are likely to affect the judicial proceeding. 515 U.S. does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly requires proof that the individual was conscious of wrongdoing. Arthur Anderson, 544 U.S. declining to explore the outer limits of this element but indicating that an instruction was infirm where it permitted conviction even if the defendant honestly and sincerely believed that the conduct was lawful. It is an affirmative defense that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. Attempts and endeavors. Section 1512 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. See U.S. v. Resendez-Bonce, 2007. The act must be substantial, in that it was strongly corroborative of the defendant's criminal purpose. U.S. v. Pratt, 2003. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. U.S. v. Irving, 2011. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. Model Penal Code Section 5.01, see U.S. v. Lucas, 2007. The Omnibus Clause of 18 U.S.C. Section 1503 prohibits an endeavor to obstruct justice, which sweeps more broadly than Section 1512's attempt provision. See U.S. v. Sampson, 2018, U.S. v. Leisure, 1988. Collecting cases. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. U.S. v. Davis, 2017, internal quotation marks omitted.